The Criminal Injuries Compensation Tribunal was established to compensate victims of crime for loss from personal injuries. If you have been a victim of crime, be that an assault, mugging, or any type of criminal behaviour culminating in a person being injured, the person is entitled to seek compensation from the Criminal Injuries Compensation Tribunal. We assist clients with cases of this nature, and if you have any questions, we can be contacted on 052 612 1999, or our email address is info@clearysolicitors.com or 015461121. This post will give you information about this type of legal application. The Criminal Injuries Compensation Scheme dates back to 1974, but has been updated in 2021 under paragraph 16 of the scheme. Compensation can be awarded to victims of crime for financial losses. There is a short 3-month time frame to submit the application to the Criminal Injuries Compensation Tribunal from the date of the crime. Late applications will be assessed on case-by-case basis, and the applicant has to qualify for an exceptional circumstance. EU Directive 2004/80/EC regards compensating crime victims, and so we are required to have a scheme for victims of violent intentional crime. There is also a scheme for prison officers injured in the course of their duties. The tribunal must administer the scheme. The scheme extends to a dependent of a victim. A Garda member injured can also avail of this scheme. An application must be made in writing within 3 months of the date of the incident. If there is a late entry, there must be an exceptional reason for same. If an application is made, the injured party disagrees with the decision, an appeal de novo, i.e. fresh case reconsideration, can be made. The amount of compensation at a tribunal appeal hearing can increased, reduced, stay the same, or what the tribunal members conclude. Applications can be made for special damages to the Criminal Injuries Compensation Authority. This includes financial losses that result from the crime. This could be loss of earnings, medical expenses, and other related expenses. There is currently no provision for the Compensation Authority to provide compensation for the pain and suffering. This issue of general damages for pain and suffering has come before the courts, and a judge has referred the matter to the European Court of Justice to address a number of issues, to include if Article 12.2 of Directive 2004/80/ECIE to provide fair and appropriate compensation for a victim, does this include both material and non-material loss, i.e. pain and suffering/general damages. The European Court of Justice will hopefully have decided upon this by the latter end of 2025, and we will have some clarity on this matter. Information about the scheme can be seen here. victimscharter.ie contact details for the tribunal. Criminal Injuries Compensation Tribunal, Tribunal Secretariat, Department of Justice, Bishop's Square, Redmond's Hill, Dublin 2, D02, TD99. Reporting the incident to the guards. To qualify for compensation, it will be necessary to inform the Criminal Injuries Compensation Tribunal that the offence giving rise to the injury has been subject to criminal proceedings, or that it was reported to the guards. The tribunal used the report from the guards in assessing the application for compensation for the criminally inflicted injury. To qualify for compensation, it will be necessary to inform the Criminal Injuries Compensation Tribunal that the offence giving rise to the injury has been subject to criminal proceedings, or that it was reported to the guards. The tribunal used the report from the guards in assessing the application for compensation for the criminally inflicted injury. Persons who can claim compensation before the Criminal Injuries Compensation Tribunal: a person who sustained an injury, victim; any person responsible for the maintenance of the victim who has suffered pecuniary loss or incurred any expenses as a result of the victim's injuries; where the victim has died as a result of the injury, and a dependent of the victim, or, if he has no dependent, any person who incurred expenses as a result of the death. Will the Criminal Injuries Tribunal oral hearing, if required, take place in private? Yes. Will I need legal representation at the Criminal Injuries Tribunal? This is entirely up to yourself. Will the perpetrator of the crime in question be at the Injuries Tribunal hearing? This is not required. Decision and appeal. Once the decision is made, if the applicant is not happy with it, a right of appeal will be given. 3. Tribunal legal professionals sit as the tribunal members who hear the appeal. The appeal hearing is de novo, meaning it is heard afresh. Appeals take place in person or online. In our view, legal representation is prudent to deal with these matters. Death of the victim due to criminal injury. In a fatal matter, the Criminal Injuries Compensation Scheme provides that an award can be made in this circumstance. We assist clients with cases of this nature, and if you have any questions, we can be contacted on 052 612 1999, or our email address is info@clearysolicitors.com or 015461121. Personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.